Aradhya and Shrutika, are you folks there in the meet?
Yes, sir.
Okay. Just check your background. It should be like mine. Yes, perfect. Aradhya, you will be giving the opening statements now.
Sir, actually, Aradhya told me to give the introduction.
No worries, no worries. Ma'am will be joining us at 11 o'clock. So once she will join, I will let you folks know. And then we will officially start the meeting.
Okay. Sir, should I change my background? Let me
Yes, yes, you may change it.
But I'm using my mobile, sir. I don't know how to change my mobile.
Same by clicking on three dots and then the background option will appear or on the video part. Aradhya, you may start. Ma'am is with us. Dr. Aishwarya Singh. Aradhya, you may start the session.
Sure, sir. Good morning, everyone. I, Aradhya, on behalf of the Nyayavani Foundation, extend a warm welcome to all of you to Nyayavani Webinar 2.0. I am joined today by my co-host, Ms. Shrutika, and together we are delighted to host this insightful session. As Justice P.N. Bhagwati once said, law is not an end in itself, but a means to achieve justice. With this belief, we at Nyayavani strive to create a space where learning meets awareness, where young minds are encouraged to think critically and understand law not just as a profession, but as a medium for change and empowerment. Now, before we proceed further, to all our participants and enthusiastic learners joining us today, your active presence makes this platform truly meaningful. Always remember, an investment in knowledge pays the best interest. Each event like this isn't just about listening, it's about discovering, questioning, and growing into confidence voice of justice and reform. Today, we are here to discuss a fundamental part of every law student's journey, moot court proceedings and advocacy skills. As Nani Palkhiwala once said, the true function of an advocate is to bring out the truth, not to secure a verdict at any cost. Moot court training is the first step in this direction. It helps students bridge the gap between theory and practice. Through it, we learn not just to argue, but to reason, persuade, and uphold the dignity of the legal process. This session will help us understand how to build effective advocacy skills, prepare strong arguments, and conduct ourselves with confidence in the courtroom. To enlighten us on this important topic, we are honored to have with us Dr. Aishwarya Singh Ma'am, an accomplished academician and a dedicated mentor. Ma'am is an assistant professor of law at Law College Dehradun, a constituent college of Uttaranchal University. She holds a doctorate in law and has demonstrated excellence throughout her academic and professional journey. Her areas of specialization include law of torts, competition law, and interpretation of statutes, and she has contributed significantly to both undergraduate and postgraduate legal education. Ma'am's scholarly interests include contemporary legal developments, human rights, and judicial reforms. She has actively participated in various national and international seminars, workshops, and conferences, contributing valuable insights to legal discourse. Known for her academic teaching style and research driven approach, Ma'am also works on curriculum development, legal aid initiatives, and capacity building programs that promote awareness and strengthen the rule of law. We are truly privileged to have her with us today. Without further ado, let us warmly welcome our esteemed speaker, Dr. Aishwarya Singh, ma'am. Ma'am, it's an honor to have you with us. The screen is all yours, ma'am.
Thank you, Aradhya. So I have submitted my PPT. Can you play that PPT?
Sure.
Yeah. Okay. Can we start now? Can we start, Aradhya?
Yes, ma'am.
Okay. So, good morning, everyone. Um, Good morning to every new and young legal minds. Welcome to this webinar, which is basically on mastering the art of moot court. I am very much happy and thrilled to be here today, sharing the three most important pillars that can make or break your performance for the moot. That is your research part, drafting part, and oral advocacy. So, whether you are the first year lawyer student who are just going to dip into your toes into moot, or seasoned participants who are gearing up for the nationals, these are the those skills and toolkits for turning a hypothetical cases into a compelling courtroom victory. So, let me just start. What is mooting? Aradha, can we play the slides? Slide number 1. Yeah. So basically, what is mooting? So you just aware about mooting is all about research, pleading, drafting, and oral advocacy. Moot court is just not about the debating only. It is a stimulation of legal practice, and you step into the shoes of advocate, lawyers arguing before a bench or a complex issue, which often drawn from the international law, or we can say that constitutional matters, or human rights, environmental law. It is just not winning the moot court always. It is the honing critical thinking and persuasions and professionalism that will serve you in your future career. Today, we will going to break it down step by step with a practical tip which can elevate your game of mooting. So for the mooting here in PPT, it is written that you must aware about is simulated courtroom, like you have to perform and play as an appellant or respondent before a panel or before a court of law, before a judges. And you must make your memorial, which is a written submission before a court of law, and then oral advocacy. And last is the judges will going to ask a question, or we can say that in other language that they will going to grill you and check your competency and confidence related with your contention and issues. So let's dive into first and foremost important thing for your mooting is the research. Research is basically the foundation of every moot court. Basically, research is the thing where your moot magic begins. But it is always where many teams are falter, because if you are uncovering the fact, laws, and precedent that will support your side, it will make your mooting game high and high. Start broad and narrow down. Begin with the problem statement. Read the multiple times your moot proposition, moot problems. Identify the core issues. Make your contentions. Identify the jurisdiction. What are the jurisdiction which is talking about in moot problem, whether it is domestic, whether it is international, or a mixed jurisdiction. To research your issues or contention, you must read and read and read your mood problems, because ultimately the research part will start only when you read and read your problems again and again. So the key tool to research for your mooting, that use legal database like Manupatra, LexisNexis, SCC Onlines, or even the Westlaw if available. For international moods, let's dive into the ICJ judgments, UN treaties, ECHR cases, and so on. Don't forget to open the sources like Google Scholar for academic articles, JSTOR, and SSRN for scholarly insights. Pro tip from my side to research for your mood proposition, mood problem, that always cross reference. A single landmark case like Visakhapatnam case, Keshwananda Bharti case, MC Mehta case, Minerva Meal case can pivot your argument. But mark these things, that particular landmark cases must verify the applicability of the case law, which relate your contention. If suppose you make your argument after your research, and in argument, in issue, there are so many contentions. Under the contentions, you cite case laws. The case laws is not just a case laws. It must refer, it must identify your particular problem related with that landmark cases. For example, if there is a environmental pollution issues, so your case must identify that how your reference case is justify your contention, like MC Mehta case, like Vellore welfare case. So, whatever you are citing in your argument, it must verify the applicability. Structure your research, categorize the thing into the fact, law, and policy. For the fact, you must build a timeline, and for a law, you must list out the what are the statutes are going to be discussed in your issues and contentions, what are the important case laws and customary international laws if relevant for your moot problems. Again, think socioeconomic impacts also, or comparative law from other jurisdiction. uh, you must research and get the information which is overloaded. So set a timeline, say 2 to 3 weeks for an initial research, and collaborate with your team. Teamwork is very important for mooting. One must handle the petitioner side, like there suppose there are three issues, so issue one is handled one person, and issue two and three handled by another person. So there must be a teamwork collaboration also. And remember, ethical research means citing properly to avoid all the kind of similarity and plagiarism. By the end, your research should arm with your with not just answers but counter the argument to anticipate the bench grilling. So research is the main important magic for your mooting. After the research, you will prepare the draft, and then after the draft, you will going to present before the panel or judges for your oral advocacy. So research is very important. Until or unless you have not done your research, best research on your part, then you will not going to defend yourself before the panel or judges, because panel and judges will going to grill you and ask you the clarity, logic behind your contention and issues. So research is very important. That is why I'm saying again and again that research is the foundation of every strong moot. And research is not just the chat GPT or any AI tool. Research is to dive into several legal database. You have I'm pretty much sure that every student who is listening to this webinar must be aware about the legal database Manupatra SEC online, and how these particular database can be used by the student, because this subscriptions has been allotted to every single colleges and universities. So student must research through the legal database, which is authentic, which is not any kind of um, related with AI or chat GPT, because we cannot rely on our research and or our draft on any tools like chat GPT or Grook or any Grow AI. There is so many AI platforms. So use JSTOR to read the articles. Use Google Scholar to read the case comments, brief case comments. Use SEC online to read elaborative form of fact, issues, and judgments of each and every case which you are going to cite in your drafting. So let's just move towards the second important part for your mooting, that is draft. Aradhya, please shift. Okay, I have already explained the purpose of mooting, that you must aware about the courtroom etiquettes and um, research and legal skills and development. Yeah, this particular PPT. So, drafting is the spotlight moment. This is the adrenaline rush, 15 to 20 minutes to argue live before the panel without any preparation. That is not going to win before the before the judges or panel. So know your memorial inside out, but be flexible. The bench will interrupt you between the oral advocacy. So drafting your basically memorial, or we can say that written submission. Craft your memorial and it is looking like the silent advocate. Basically you write everything what you have researched and related with your issue and contentions. So once researched, it's time to draft your written submission, often called a memorial or a brief. This is your case on the paper and judges will going to read it first, so make it impeccable. And you must follow the format while drafting your case, like cover page, table of content, index of authority, statement of jurisdiction. Jurisdiction is very important. After reading the moot problem, you must identify that where the case going to be filed. So jurisdiction is very important. So statement of jurisdiction, then fact, issues. Sometimes the moot proposition have their own issues and sometimes they ask you to frame your issues. So issues is also one of the important part of your drafting. Then summary of argument. Summary of argument means if there are two issues, then on the basis of two issues you have to summarize your argument in one page or 1.5 page. So this is the summary of argument, and after that the argument advanced start, where each and every issue have 2 to 3 contention, and under those contentions you have to have specify and clarify your contention with the help of case laws, statutes, precedents, etc. And after that, after the argument advance sum up, the prayer. Keep it concise. Most moot limit 20 to 30 page. So keep your drafting skill concise. Writing tip from my side, that use the clear and formal language. Do not use and do not use the phrase or slangs words. Avoid the jargon unless it is defined. Okay, so each argument should follow the IRAC rule. IRAC rule is the rambar for your drafting skill. Like issue, first I identify the issue, R identify the rule, A identify analysis, and C identify conclusion. So your writing skill, your writing submission, written submission, that is drafting, is must follow the IRAC rule: issue, rule, analysis, and conclusion. And back every claim and citation. Footnotes are your evidence trail. Footnotes should be there, you cite Vishakha versus state of Rajasthan case. So you must cite in footnote the citation, the full-fledged citation, because in your judges interaction, with your judges interaction, the judges can ask what are the citations. So you must aware and you must cite each and every things in the footnotes as your evidence trail. And for the argument section, build logically. Start with the strongest point. Start with the strongest point means use the clarity and logic behind your contention. Use headings and subheadings for the readability, and persuade subtly. Phrases like "it is humbly submitted that." It shows the respect. It shows the courtroom etiquettes. So use these words before your submission of panel. Teamwork here is very important. Divide the sections, then review collectively for consistency. Edit ruthlessly, out fluff, ensure the flow. Tools like Grammarly will help your drafting skills. But peer review also is very important to ensure your drafting. So use these web apps to clarify your draft or written submission. And a stiller memorial does not just state the law, it tells a story, weaving the fact and precedent into a narrative that compel the judges to rule in your favor. So basically, we say that na, first impression is the last impression. So when judges sit as a panel before you, so first, the written submission will going to attract the judges. After that, your oral advocacy will help them to adjudicate the matter, right? So drafting is important. Drafting is very important to identify, to clarify your logic, your issue, your contention before a court of law. And you must aware about your memorial, each and everything whatever you have right at each and every page. You must aware, you must read down each things what you have cite there, the case laws, the sections, the articles, the journals, everything. Next is third important and very important thing for your mooting is oral advocacy and oral argument. Basically, it is a spotlight moment. So it is for 15 to 20 minutes to argue live as an advocate and as a lawyer before a panel. So preparation is very important to practice yourself again and again, and start your opening like this. May it please the court. I am counsel for the petitioner, and today I will address the issue 1 and 2. Likewise, you will start your opening. Um, Mark my thing that be polite and maintain the eye contact, even on the webcam. For example, there is a virtual moot court going on. So on webcam, also make and maintain eye contact with the judges and speak clearly. Pace yourself, no rushing. बिल्कुल आराम से handling the question, and listen the question of judges fully, carefully, and then answer directly. Suppose you are not aware about the answer, so your researcher, there are three-person in a mooting: plaintiff, or we can say that petitioner, respondent, and researcher. Researcher should be also gear up each and every time. Once question asked by the judge, then researchers should gear up with the things that this is the answer. And if the petitioner or respondent not going to answer upon those questions, so researchers should be aware and give the chit on sticky note to the petitioner or respondent. So listen carefully the questions of judges and then answer directly. If stumped, like if you want to answer, then say, Your Lordship, I would like to refer the page so and so, like page X of our memorial, or pivot gracefully. Ask gracefully that, Your Lordship, I would like to refer this page, and this is the thing which is cite on this particular page. And for the rebuttal, if you want to rebuttal, then be concise and attack the weakness without the aggression. Attack the weakness means attack the weakness on the opposite party if you want to go in rebuttal. Body language in the oral advocacy is very important. Stand tall, because the marks which is going to be given by the judges, it is also one column which is related with your professionalism, courtroom etiquettes, body language. So, body language is very important. Stand tall, use gestures friendly. For virtual moods, ensure that good lighting will be there and stable connection will be there. And pro tip from my side is mock rounds are the golden opportunity. Before going to the nationals or before going to the mooting, actual mooting, you must go mock rounds. Mock rounds means you must go for the preparations, round and round preparations, and it will simulate with your seniors or online groups. Like we used to frame the mock performance day by day. If I'll get to know that my student is going for the national or for going any other mooting, so we will structure the mock rounds for those students, so that practice will going on before the actual mootings. So record yourselves to spot the filler words like okay, yeah. These are the words you have eradicate from your oral advocacy. And in essence, oral argument test your poise under the pressure. You are under the pressure at the time of contention and issues presenting before the court of law. So basically, oral advocacy or oral argument test your pressure, and it is not about being the loudest. It is about being the most convincing with the judges, with the panel. So moot court for the moot court, these are the three pro tip for the every students. Aradhya, open those slide where I have cited the examples. No, this is not the no. Yeah, this is the example for a moot court scenario I have cited here. It is for those who is first learner and first year student who wishes to go in moot court. Let's just create a moot court scenario here. This is the example. Let's say the case is related with constitutional law moot, okay, and the issue is whether the restrictions on social media post violate article 191A, as article 191A is the right to free speech and expression. So whether it violate 191A, this is the issue in that constitutional law moot. So how you will identify the jurisdiction, how will identify the research, how will you make your written submission, how the oral advocacy going on. So first you must aware about the article 191A because it is written in your constitutional moot and issue, so you must aware. Second, research the case laws from Manupatra, LexisNexis, SEC online, research your case and make a written submission, make a draft. And while arguing your draft, while arguing before the panel, how you how you present your case before the panel. Likewise, may it please the honorable court, my name is so and so, appearing on the behalf of petitioner, and the issue before this honorable court is whether the government restrictions on the digital expression violate the fundamental right to freedom of speech and expression under article 191A, and I will be addressing to submission. Then the petitioner will going to submit the two submission. First is that the restriction fails the test of reasonableness under article 19.2. 19.2 is the reasonable restriction which is given in article 19. So this particular format coming after the research, na, so petitioner must content before the judges, before the panel, after the full-fledged research. And then after that, what petitioner will going to say that it infringe upon the principle of proportionability, which is laid down in the case Puttaswamy versus Union of India. Now the judges can ask how your case Puttaswamy versus Union of India is related with your contention. So you must identify that case Puttaswamy is related with the right to privacy case. So basically, this is the scenario. This is the small scenario. This is the small thing which I would like to state before you, like how you will going to oral advocacy before a judges or panel. So, dear student, for the mooting, the three things is very important. You must research the thing, and before research you must read your mood problem again and again. I would say 15 to 20 times read your mood problems, and then highlight the important things. What are those things you must highlight? The statute, what are those statute is citing in this particular mood problem. Second, the jurisdiction. Both the things is very important. And third is what are the actual issue arising in this mood problem. So this is the important thing which you must do before the research, and after doing these things then move towards the research, and then after the research move towards the written submission, and then after oral advocacy. And while doing the oral advocacy, etiquettes is very important, teamwork is very important, legal skills is very important, clarify your contention before the panel, very important, and the logic behind your uh, judgment, the logic behind your contention, the logic behind your issue. Here, this particular page is talking about courtroom etiquettes and professionalism, because this particular legal field, we say that it is a professional side, it is a professional thing. हम बोलते हैं कि LLB, BLLB, BBLLB is a professional courses, because after the you are passing out, that you must aware about the etiquettes of courtroom. Your phones should be switched off, your kindness, your way of speaking, your way of standing before a panel, before a judges, even in the real court law. So learn how to address before judges, learn how to maintain the decorum. Professional behavior is very important in moot court also, and in real court also. And your confidence and clarity under the pressure is also going to be checked by the panel and judges. So it is important. So this is from my side. If any doubt or anything the student want to ask, I'm open for the question. I have discussed these things, Aradhya. I have discussed all the things. Yeah. For the research, there is a primary source, secondary source. Primary source is case laws, and secondary source is um, uh, आप आपके जे स्टोर हो गए, scholars, Google scholars हो गए. These are the secondary sources. So this is the things which can help for your research and written submission and oral advocacy. This is the only three things on which the mooting is totally based on. This is only the three things. Now you can practice and make your because drafting skill is also very important. You have researched the thing, you have cite, and you have clarified that yeah, this is the case laws which I have to cite in my research, in my oral, in my drafting, but you are not aware that how to draft your statement, how to draft your written submission. So it is very important. Drafting is very important. Like you cite your issue, and under those issues, which the issue is given by the particular institution, under those issues, which are what are the contention which can be helpful for your side before a panel or judges, it is also very important. That contention you will have to find out. So it is important. Drafting is very important, but drafting is totally based on research. So these are the three things which is interrelated, interdispensable. Um, Without these three main element, three main pillar, nobody can do a moot. Mooting is basically a practice. You understand the theories in your classrooms, but you practice those theory in the courtrooms via moot court. Okay, there is
Thank
a
you so much,
question.
ma'am, for
Yeah.
that insightful and inspiring session. Your words have given us a clear perspective on how moot court training enhances advocacy, discipline, and confidence, qualities that shape every great lawyer. As Mahatma Gandhi once said, in doing something, do it with your whole being or not at all. I'm sure today's session has inspired everyone here to approach advocacy with full dedication and purpose. Now we would like to open the floor for the question and answer session. This is a great opportunity for all of you to ask your queries directly to ma'am and seek clarity on any aspect of moot court proceedings and advocacy skill. If you have a question, please feel free to drop it in the chat box and we will take them one by one. Before that, I request all the participants of our upcoming moot court competition to stay in the session after the conclusion of the session because there will be some briefing regarding moot court competition.
So I can see one question in chat box by Tarini Bharadwaj, that can you elaborate on what is the exact strategy or a roadmap to a successful moot court competition? Tarini, basically, see, mooting is basically those um, practice which is not only debating before a judges or before a panel. For mooting, you must first understand the moot problem. So I would suggest from my experience that the exact strategy for your moot court competition will be, first read your moot problems and write down at one page about the brief summary, because it is very important. You have to elaborate your fact to the judges. So first, brief summary of your fact, identify the jurisdictions, and then research the things. After researching all the things, you have to elaborate in your written submission. This is the first and second parameter. The third parameter for your moot court competition is oral advocacy. मैं आपको सिर्फ यही बता सकती हूँ कि you whatever you have researched and whatever you have draft, you must aware. And if you are, suppose if you are not aware about the things, the question which is asked by the judges or panel, or you are not explaining clearly and logically before the court of law, your gesture should identify that you are aware about the things, you are aware about the contentions, you are aware about your counsel's issues. So important thing is research is very important for a legal student. If you are not going to moot court also, the research is very important. So stay calm in the court, and stay confident is very important before the panel in moot court competition. Even if you are aware that you are going to be losing the case, but still stay calm and have a confidence before the panel. Okay, second question from Asif Khan, that ma'am, how a memorial is written, means how it is structured. Good question, Asif. Basically, there are two format to form a memorial. First is if there is a issue given to you, suppose if there is a issue, and issue is given two issue is given to you from the institute. Okay, so on that issue, first you have make the summary of um, argument on those particular issue. Suppose I have given the example that this is the violation of article 191A, this is the first issue. Okay, so you have to summarize this particular first issue in one page or 7 to 8 or 10 lines. Okay, and after those summary, you need to elaborate your issue in argument advance. So this is the two things. First is summary of argument, yani jo those are the issues which you are going to discuss, the summary of those argument. And then in argument advanced, suppose one issue is, it is the violation of 191A or not, ye issue hai. So on that you have to frame two or three contention, like it is not the violation of article 191A because there is a reasonable restriction, article 19 subclause 2. So you need to describe these things, how article 19.2 reflect article 191A, what are the those case laws, and is there is any other statute also which talking about these violation of article 191A, right to speech and expression or press. So this is the, these both the things are very important to frame your memorial. I can show you the memorial. I can uh, um, give the memorial to the Aradhya, and she will going to show you that how the memorial can draft. In memorial, it is two things is important: summary of argument and argument advanced. And under argument advanced, you need to cite articles, case laws, statutes, everything which can clarify your contention. Okay, next question is how many case laws should be cited to justify an issue? Uh, there is no limitation of the case laws because the landmark judgment is essentially have to have put up in your memorial, and you have to cite only those landmark judgment which is only justify your contention and issue. You need to cite only those landmark judgments. So there is no limitation to citing the case laws, but there is a limitation of preparing memorial. For one memorial, there is a limitation of page, which is 20 to 30 page only. So ultimately, if there is a two issue or a three issue, under those two or three issues, you need to cite the contentions of your side. So under those convention, how many cases you can cite? So there is no limitation for case laws, but there is a limitation for memorial pages. का limitation होता है only 20 to 30 pages. Next question. Can you please let us know about how we are supposed to refer our compendium document in online mooting in order to let the judges follow what we are exactly content from the judgment we are referring? Okay, judges will already um, refer the memorial. जो भी आपके institute के होंगे, they will going to refer all the your compendium and memorial to the adjudicating judges. So you need not to worry about that कि how you will going to exactly refer those things that will already taken over by the adjudicators. Next, if we have not answer of the question of judges, how to deal with the judges or how to handle that situation, you need to say that pardon your lordship or ladyship. Pardon your lordship or ladyship with a smile. Just say pardon. इस सिचुएशन को आने ही क्यों देना है? Just prepare your researcher will let you know that if you are not aware about the question which is asked by the judges, let you know, let your researcher be aware and research the things and uh, give it the answer to you. And then okay, if the researcher is researching your question, then how you will say your judges, right? You have to say that just a moment of hurdle, ladyship or lordship, just a moment. Okay, and then you need to research and then answer the judges. Ma'am, could you please suggest how to effectively prepare for the rebuttal round in a moot court? See, it is the part of researcher. Researcher will going to make all the rebuttal answers, and rebuttal is basically you need to identify the weakness of opposite party, opponent party, and then go in the rebuttal round. Always identify the weak points from the opponents. How can we effectively present in pre-rounds of moot? I have already given this question answer. What are the best practice and key element to consider while preparing a compendium for a moot court competition to ensure it effectively support oral advocacy and impresses the judgment? See, you need not to impress the judge. You just need to clarify your advocacy logically. Okay, what are the best practice and key element to consider while preparing a compendium for a moot court competition? Yeah. And how are we supposed to provide the compendium? Because this moot court is in virtue. इसका भी मैंने answer कर दिया है. Does any guideline or direction given by government or statutory body which is also related to inserted content memorial AA mandatory obligation? Any guideline or direction which is given by government or a statutory body? Jaspreet Kaur, please clarify your question. Uh, Aradhya, if there is more question, then please
Yes,
connect.
ma'am. I guess
Yeah.
there is no more question.
Okay, so can
Uh,
we leave? Hmm.
uh,
As
with- okay.
Yeah,
So thank you so much, ma'am, for the session and for addressing all the questions. There is one question from my side. With your due permission, I would like to raise it.
please,
Actually,
please.
actually, in our moot court competition, we have given the opportunity to many folks from Pan India, and some of them are from the government law colleges, and they don't have the privilege to have the access of Manupatra or SEC subscriptions because, and they can't individually afford this because they are very costly. So, what are there any alternative ways to research if they are not having the access to such research tools? Like law, Qanun, and etc. If they are good for
Yeah.
authentic research.
Yeah, it is authentic live law, latest law, and Indian Qanun. It is equally helpful for the students for the research. And
Yes.
after that, in every college, there is a library. And I'm must aware that there should be AIR, SCC, वहाँ पे होगा. So they can refer those library documents also, instrument also.
Indeed, ma'am, you are right. But actually, there was no such subscription in my college as well. So that becomes a relevant question to me as well. And there are
Okay.
many other folks. They raise
Okay.
the same issue.
Okay. So
So,
yeah, live law and latest law is very good platform. It's such a good platform from where you can cite. And even after these things, you can also refer the JSTOR and scribe भी एक website है scribe
yeah.
करके. And Google Scholar is again for some document it is free, for some document it is paid. So I will not going to give you suggestion that go on a Google Scholar. Yeah.
Thank you, ma'am, for addressing this. Oh, Swaradya, if there are any questions, you may raise them. Else conclude the session.
I have a question.
Yes.
Ma'am, actually, I don't have access to different sites. What else I can do?
Just now I have given answer that you can cite the free. You can help take help from free websites like latest law. On latest law, there is a case laws. There is news also cited there, and live law is also important platform. Um, these are some of the platforms which is free for all the students. Yes, Indian Qanun,
Okay,
exactly, Indian Qanun.
okay, thank you, ma'am.
Thank you.
ma'am,
Yeah.
ma'am, I have a question. So I have a moot court competition, but the case is like an international case. So where do I refer for the case laws, all that, ma'am?
From ICJ, International Court of Justice cases, you can refer in your moot proposition memorial.
Okay, ma'am.
And
Mm.
from
Okay,
UN
ma'am.
treaties, if any treaties have been done related with your moot problem, yeah, if any covenant and conventions, then you can cite in your memorial.
Okay, ma'am.
Ma'am, how are we
As we
supposed to send the compendium in this moot court because it's in the virtual form? So, any
No.
link or any number?
Folks, we will be sharing all the details about our moot court competition after this. So if you have a common question about the moot court, so you can raise it.
Okay, okay. No, thank you.
If there's no more question, I'll go with the vote of thanks. As we conclude this enlightening session, I'd like to express our heartfelt gratitude to you, ma'am, for your valuable time, insights, and encouragement. Your guidance has been truly inspiring and will certainly help our students become more confident and capable advocates. On behalf of the Nyayavani Foundation, I extend sincere thanks for supporting our mission to empower students through experimental learning. As part of this initiative, we are thrilled to host a Nyayavani Moot Court competition offering students a real world platform to refine their advocacy skills. We have kept the participation fee minimal to ensure that every talented individual can benefit from this opportunity regardless of financial constraint. Thank you once again, ma'am, for being a part of our journey and for inspiring students across India. We are confident that this moot court will be a transformative experience for all the participants, shaping the new generation of leaders and change makers.
Thank you so
Before
much.
we come, thank you, ma'am.
Thank you so much, ma'am.
Thank you. Thank you.
Before we conclude, I'd like to take a moment to address all the participants of the Nyayavani Moot Court competition, especially because the competition will be concluded entirely in virtual mode on Zoom. So there are a few important points I request everyone to carefully follow. First, please make sure you are well dressed in formal or courtroom appropriate attire on the day of the competition. Even though it is online, your presentation and discipline matter a lot and create your first impression before the bench. Secondly, kindly check your internet connection and a device in advance. Preferably, join using a laptop or PC for clarity and smooth access to documents. If you are using a mobile phone, please keep it in horizontal or landscape mode so that your video frame is proper and stable. Third, please ensure you have Zoom downloaded and updated. Spend a few minutes before becoming familiar with the basic control, mute, unmute, camera on or off, and especially joining breakout rooms. During the competition, each team will be moved to breakout rooms and our court masters will guide you, so there is no need to worry, just stay attentive to the instructions. Fourth, I strongly encourage each team to practice once together before the competition, what we call a dry run. This should include your speaker transition, timing, and how you will respond to questions. These small preparations make a huge difference in your confidence and delivery. Fifth, please remember that courtroom etiquette remains the same even in virtual mode. Keep your camera on, sit in a quiet place, maintain proper posture, and address the bench respectfully with the phrases like "May it please the Honorable Court," "Oblige your Lordship," and so on. Lastly, a very important reminder: the final date for the memorial submission is 8th November 2025. Kindly make sure that you submit your memorial on time to avoid any procedural issues later. We want each of you to perform your best. Our team is here to guide you throughout the entire journey. On behalf of Nyayavani Foundation, I request you all the very best for your preparation and upcoming rounds. Thank you. Stay connected and we will
Shrutika,
forward. Yes, sir.
there are few points left. I guess there were few questions raised by the participants.